last time, I'll probably be finding it.
Well, good morning, everyone. Thanks for joining us virtually. This is the New Hampshire Tech Alliance. My name is Jim Reedy. This is She and Finney. We're the hosts of the program, the monthly HR event. I'm thrilled that you could all be with us today. We've got nearly 300 people registered for today's event, and that's amazing this time of year. But it's an important topic, and we've got a great presenter. But before we do, I just want to quickly mention that next month, yes, 2022, if you can believe it, we're going to have Katie Geary talking about tips for employee financial health and wellness in the new year. We're all going to be talking about diets and fitness in the new year and other resolutions, but financial wellness is something that we should be focused on as well. But in the meantime, something that gets to the bread and butter issues of HR, and that is wage and hour issues, everything from time cards to payroll to related issues. And I can think of no better presenter than my partner, Brian Bouchard from our Portsmouth office. Brian is a litigator and a counselor with years of experience dealing with these important issues. And Brian's here to talk about the top 10 wage and hour violations from 2021 and related wage and hour issues under federal and state law. Please welcome Brian Bouchard.
Okay, thank you, Jim. Happy to be with everybody this morning. The last time I did a presentation was about 1 month ago. Excuse me, I got my booster yesterday, so I'm a little congested. But the last time I did a presentation was a month ago, and it was on the OSHA ETS. And the night before my presentation for the Portsmouth Chamber, the Biden administration announced that it was suspending enforcement of the ETS. And as soon as I made that announcement at the beginning of my presentation, I had about 100 people at the beginning. I made that announcement, and in 4 minutes, I was down to about 40 individuals. So I am very happy to be presenting on something today that is already happened and is of vital importance to everybody in the HR field. Wage and hour health, sort of the fiscal health of wage and hour compliance is of the utmost importance, particularly in New Hampshire, where there are liquidated damages, which we'll talk about, but also in states like Massachusetts, where the liquidated damages can be quite intense and automatic trebling for simple wage and hour violations if an employee is not paid their proper wages. And those can really add up. I've done enough of this work to know that. A couple of days ago, someone was asking me, how common are wage and hour violations? Because I haven't been audited yet. My business hasn't been audited yet. And my response to her was extremely common. And I sort of said in jest to her that, I think any attorney in my office in the labor and employment field could walk into, practically any business on Elm Street in Manchester, for instance, and find at least 3 wage and hour violations that would result in significant fines and penalties for the organization, maybe even wage adjustments, something that the organization is not going to want to pay and would rather use for other aspects of the business. And that's just because this area of the law is very nuanced, it's dense, it sometimes seems like it's conflicting, and there are many traps for the unwary, as you'll see today in our presentation, which is really fundamentally the top 10 wage and hour violations for the state of New Hampshire. So here's our agenda for today. We're going to talk about the top 10 wage and hour violations. That is published by the New Hampshire Department of Labor. Every year they go through and tabulate, statistically what the top 10 violations were. And they also provide us with some other statistics as to enforcement, how many dollars they were able to recoup on behalf of employees and in civil penalties, how many audits were done, et cetera. Throughout that presentation, we're going to be talking about best practices and what to do to avoid becoming one of the businesses on this list in terms of a wage and hour violation. We're going to talk about US DOL updates from the wage and hour division specifically. We're not going to be talking about the OSHA ETS in too much detail. We're going to mention it just because you kind of need to, given everything that's going on. And finally, we're going to talk about what to expect from the US DOL in 2022. Now, a brief disclaimer for the presentation. While I am an attorney and I do this type of work on a regular basis, this program is for educational purposes only and is not a substitute for legal advice. If you see something in this program that you have a question about, that's great. But I would highly recommend that if you do have a question, that you consult with a qualified labor and employment attorney about that question, because I don't want to see anybody here in this presentation end up having a top 10 wage and hour violation in the new year. Finally, if you do have questions for me today as part of the presentation, please put them in the Q&A section of Zoom. I think the chat is disabled. I might not be able to see them as the presentation is going on because of the way PowerPoint is working, but I will make my best effort at the end of the presentation to address any questions that you may have. So just put them in the chat and we'll go forward. All right, so here we have some statistics from the Department of Labor in New Hampshire. And really these are enforcement statistics, and we're going to sort of build into the top 10 wage and hour violations for the year by looking at these first. The number of wage claims filed with the NHDOL was 473 this year. That is on par with what we've seen in previous years, which I think last year was around 480. So that is, what we'd expect. COVID doesn't seem to have affected that in any significant degree. Keep in mind that it is quite easy for any employee who feels they have been aggrieved because of wrongful payment or because, withholding of wages, whatever it is, to file a complaint with the Department of Labor and to get a hearing. It is as simple as filling out a form and attesting to that form and then filing with the New Hampshire Department of Labor. So that's something to be cognizant of when you're reviewing or auditing yourself, to make sure that all your I's are dotted and all your T's are crossed, because it is so easy to file something with the Department of Labor. Same for the United States Department of Labor as well. It's a form that the employee fills out. The number of inspections conducted in fiscal year 2021 was 820. Last year was 847. The year before that was 670. So we are still in a little bit of a jump right now. Could be due to COVID. It's hard to tell. Most of the time, the Department of Labor would do on-site inspections, particularly if it's any type of safety violation it was concerned of, and it still will do on-site investigations for safety concerns. But now the Department of Labor, I think, has shifted to doing more remote investigations. And, as part of that, it is able to do, really more investigations than it would be able to do otherwise, because it doesn't have travel time to sites throughout the New Hampshire state. The amount proposed in civil penalties resulting from these inspections is $2.7 million. That is almost $1 million jump from last year, which was 1.6 million. So what that tells me is that while the number of investigations is actually lower than last year, that the civil penalties have greatly increased, and that is with a Republican administration right now in the State House. You would certainly see that result at the USDOL with the Biden administration having enhanced focus right now on wage and hour violations. But I was quite surprised to see the jump here. I'm not sure exactly what the explanation is. It could just be the case that there were, more egregious or more significant violations this year. Last one on this slide is the amount collected in fiscal year 2021 for civil penalties from the inspections that were done, and that is 415,000. So if you're looking at this, it is certainly suggestive that if you have an audit and if there are violations found in the civil penalties proposed, that there is room for negotiation with the Department of Labor. And I encourage everybody who is audited to retain counsel and to engage in those negotiations in good faith, because as you can see, there is a lot of room for some type of reduced penalties or reduced wage adjustments, as shown from the statistics. Last year, the amount collected was 376,000, so we're about on par from last year. A couple other data points from the NHDOL. The amount collected in fiscal year 2021 in wage adjustments was 1.3 million. Again, that trends with last year. And the number of training sessions the New Hampshire Department of Labor offered in the last year was 15 webinars with approximately 2,000 employers attending. If you have not attended a webinar by the Department of Labor, I highly recommend that you do. One, they're actually extremely well done and they're very informative. Two, I cannot tell you how persuasive it is when you are in the middle of an audit or an investigation by the New Hampshire Department of Labor, and you have civil penalties that are proposed against you, the company, and you are able to tell the inspector and the Department of Labor that you attended some of their webinars. It's one of those little factual tidbits that goes a long way in reducing the civil penalties proposed, because it shows the New Hampshire Department of Labor that you are in good faith trying to make an effort to comply. Compliance errors happen all the time because this body of law is dense, it's nuanced, it's tricky, but you've made a good faith attempt to do it. You've gone to this presentation, and you've also gone to a presentation by the New Hampshire Department of Labor. So I greatly encourage everybody to go to the Department of Labor's website and find out when they're doing another webinar. They have them on a variety of topics, but mostly it's just, New Hampshire labor law. And to attend one, it's virtual, it's free, and it's highly beneficial in the event you get into an audit. And if you don't get into an audit, it's still informative. Okay, so again, talking about audits, there was an amendment to 273-9, which is the governing statute for the Department of Labor, that says that all inspections performed by the commissioner, which is the person who heads up the Department of Labor in New Hampshire, shall be proportional and relative to the potential violations being investigated. I have used that clause to some extent in an audit. What proportional means in this context is, the reference to the issues at stake in inspection, to the degree to which the alleged violation involves a physical injury, the potential for lost wages and how big those lost wages may be, and the amount in controversy, and the parties' relative access to information. This statute is very important because it does circumscribe what the Department of Labor can look into in terms of an audit, and allows the business, likely through counsel, to say, all right, what you're looking at here is very narrow, and pursuant to 273, 9A, we're going to narrow that investigation to what is proportional to what you're looking at. So keep that in mind if you are ever audited. So with that, we're going to jump into the top 10 violations as determined by the New Hampshire Department of Labor. Number 10 on the list, so we're going to go from 10 to 1. So this one would be the least common, and number 1 would be the most common. And number 10 is failure to have a written safety plan and joint loss committee. So every employer in New Hampshire with 15 or more employees must establish a joint loss committee. That committee is responsible for the development of a workplace safety plan and workplace safety programs. They also have to, publish rules and regulations for the workplace on alternative programs to permit injured employees to return to work, such as having light duty work, and programs on continuing education for safety issues. The Joint Loss Committee has to meet regularly and maintain minutes, and those minutes have to be available to anybody in the organization. Okay. By meet regularly, I would say at least once a quarter, or if you're doing once a quarter, I think you're doing fine. Where a lot of businesses get into trouble with respect to the Joint Loss Committee is not meeting frequently enough, or not having a record of those meetings that satisfies the regulations in the statute. Okay. The Joint Loss Committee also has to be a balance of management employees and employee representatives. So consider that when you are forming your Joint Loss Committee. And of course, if you don't have a Joint Loss Committee, now is the time to do so. This is a very easy one to check off the list. If you don't have a Joint Loss Committee, you don't have a safety plan, create one. Believe me, it is not difficult for the Department of Labor to show up or send you a letter saying, please send us your safety plan. We know that you have more than 15 employees, which brings us to the requirement of a safety plan. So every business with 15 or more employees must develop and submit a written safety plan to the Department of Labor, and they have to have it on record. The safety plan establishes the rules and regulations for workplace safety. It addresses, what the company can potentially do to bring someone back to work who is injured. It addresses the process for warnings, job suspension, job termination, if an employee is violative of the safety rules adopted and approved by the company. It has to be renewed every 2 years, and it has to be submitted to the Department of Labor. So keep that in mind. That's another frequent violation, is that a company, while they have a safety plan, hasn't renewed it. So what I encourage everybody to do at the end of this presentation is check to see when the last time your safety plan was renewed and submitted to the Department of Labor, and also check to see whether you have minutes, coherent minutes from the last meeting and when that last meeting was. It should be, within the last quarter. Now, for number 9, the failure to pay minimum wage for all hours worked. As many of you know, non-exempt employees must be paid minimum wage for all hours that they suffer or are permitted to work, because the work is not really clearly defined anywhere in the New Hampshire Department of Labor statutes or regulations, nor is it defined in the FLSA. But if you have an employee who, even if they're working in an unauthorized capacity and that work is benefiting the company, they have to be paid for that work, which is something we're going to talk about in more detail later. But more importantly, they have to be paid the minimum wage for that work. New Hampshire minimum wage tracks the federal minimum wage, which is $7.25 an hour for federal contractors. It's going to increase to $15. We'll talk about that later. So where some companies run afoul of this is they don't consider equipment that has to be provided by the employee that may drop the employee below the threshold for minimum wage, okay? And that has to be taken into consideration. If an employee is required to, provide their own internet, for instance, for working remotely, which became an issue during the start of the pandemic, and internet is obviously crucial for being able to work remotely. And the cost of that internet drops the employee's hourly regular rate below the minimum wage, well, that's a violation, okay? Other violations occur when you have draws against commissions, and the draw is in effect brings the employee below the minimum wage. You also have tip crediting issues and fluctuating work week issues, where you're allowed to pay a non-exempt employee a salary, but the salary has to ensure that the employee is paid minimum wage for all hours that they do work. Some recommendations here is, we're going to talk about this as well a bit later, is use apps to track hours, okay? Having written timesheets, I don't think is sufficient anymore, unless it is guaranteed that the employee is reporting to a specific area in the workplace and they're reporting there every day and they only do that work at that part of the workplace, okay? I would have some type of electronic or internet-based system where an employee is able to track their hours. That enables an employee, if they are working remotely, if they are working outside of the office building, to log their time and to ensure that they are being paid minimum wage for all of their time. At the same time, you want to develop policies with clear examples and have training for every employee on the company's policies for clocking in and clocking out. It is the employee's obligation to provide a record of hours worked. At the same time, it is the employer's obligation to ensure that a record is provided, okay? So you definitely want to make sure that no one is working in an unauthorized capacity without clocking in and making sure that they are paid for that work, because that is a violation that is going to come home to roost on the employer and not the employee. That brings us to number 8, which is failure to provide written notice of wage. Folks, this is an easy one. This is an easy one. I am surprised that this is still on the list, okay? All employees must receive written notice of their wage, their pay period, their payday, and the description of all fringe benefits that are going to be given to them as an employee of the entity, okay? The disclosure, and this is where I think a lot of companies get into hot water, the disclosure must be made at the time of hiring. So when the offer letter goes out, you have to disclose all of this information to the employee. Or if there's a change in the employee's wage, the pay period, the payday, whatever it is, that disclosure has to be made in writing prior to the change taking effect, okay? Now, the best practice here is to send all this information to the employee in an email or in a written capacity and get some type of acknowledgement of receipt from the employee saying that, okay, I have received this information, that's it. And then save both the written record provided to the employee and the employee's acknowledgement of receipt for a period of 3 years. So that way, when the New Hampshire Department of Labor comes knocking at the door, the entity is able to provide that information with alacrity. Okay, so ask yourself right now, for every employee that you have, are you able to provide a written notice of the wage for that employee, their pay period, their pay day, and the description of all fringe benefits, and provide the employee's acknowledgement of receipt? If you are not able to do that, your goal for the new year is to fix that immediately, because there are civil penalties associated with this, sometimes up in the thousands of dollars, plus the hassle of dealing with an audit that you don't want to deal with for something so simple. For those of you who are wondering, fringe benefits as defined in New Hampshire law includes things like paid vacation, sick leave, holidays, bonuses, severance pay, personal days, and payment of personal expenses, or not personal, business expenses by the company, pensions and retirement plans, and the like. All of that has to be disclosed to the employee as part of this written notice. Now, as part of the disclosure, the company also has to furnish the employee a statement of applicable or appropriate deductions that are allowed under New Hampshire statute. There's a little bit of a conflict here between what the statute says and what the regulations say. The statute says that you have to disclose a statement of applicable deductions. The regulations say that you just have to make a statement available, okay? And that could be referring an employee to the actual statute, or it could be referring an employee to a poster in the workplace. So keep that in mind. Number 7, illegal deductions from wages. This is always on the list for as far back as I can remember. An employee, has to be paid their wages, and if a company is going to take any deductions from the wages that are earned, they have to be anchored in RSA 275-48. If they're not, you're in hot water. Okay. Appropriate deductions include things like union dues, taxes, FICA taxes, retirement planning, 401k, voluntary uniform cleaning, certain types of loans, and tuition. Some of these deductions require the employee's written authorization that the company is then required to keep on record for a period of time, generally 3 years. Others limit what can be deducted, or what amount or percentage can be deducted from the employee's wage. And others require, a voluntary request from the employee to have a certain amount reduced from their wages each pay period. It's not something that the employer can coerce the employee to agree to. So you want to make sure that you have evidence of some type of voluntary, uncoerced request from an employee. Bottom line here, before you deduct anything from an employee's wage, consult RSA 275-48. And I see this on LaborNet with some frequency that I'm going to mention it now. Never, and I mean never, deduct an overpayment. You paid an employee too much from future wages. Don't do it. It's going to come back to bite you. There's other more appropriate ways to handle that. Penalties for violations here include civil fines and wage adjustments. All arrangements, again, should be in writing and recorded. You also want to be careful, although I don't think this violation is intended to capture this necessarily, but just be cognizant of the fact that when you have somebody who is a bona fide exempt employee under the FLSA regulations, you also want to be careful in making any type of deductions from that person's salary, because a salary or being paid on a salary basis is one of the tests that is required for someone to have a bona fide exemption from overtime. And if they are not paid a salary for all hours work, if they are, get some type of reduction because of poor performance, for instance, then it seems that they are more an hourly employee and that their salary is contingent on performance of some type or quantity of work performed, which puts you into a whole heap of trouble in that you potentially lose the exemption if you don't have a safe harbor written into your policies. And losing the exemption for an employee is significant because at that point, there's 2 to 3 years of back wages potentially that the employee can get. And the back wages we're talking about here are overtime, which is generally paid at time and a half, except in certain circumstances. So keep that in mind when making any type of deduction from an exempt employee's wage as well. It's another violation, but it's also a significant one. Number 6, workers' compensation insurance. Every employer in New Hampshire with 1 or more employees must procure and maintain workers' compensation insurance. Coverage must extend to all employees. This most often occurs with misclassified independent contractors. The benefit of independent contractors are clear. They don't have to be paid minimum wage. They don't have to be paid overtime. They don't have to be provided benefits. You don't have to have I-9s for them. You don't have to keep any records for them. Most of the time, if you have a bona fide independent contractor, you just provide them with an independent contractor agreement saying they're not an employee. The other benefit of having an independent contractor is you don't have to procure workers' compensation for them. In fact, it is the independent contractor who should have his, her, or its own workers' compensation insurance. Bear in mind, however, that there are very strict circumstances and very established tests as to whether or not someone is an independent contractor. The New Hampshire Department of Labor has its own test. The New Hampshire Employment Security has its own test. The US DOL kind of has its own test. It did, and then it didn't, and then it did again. We're going to talk about that. And the IRS also has its own test. And there also is a test in Massachusetts that is in the statute. Generally speaking, though, the hallmarks of a true independent contractor are that the independent contractor performs work that is non-integral to the company. Think of a dentist office, for instance. If a dentist hires an accountant, well, an accountant isn't within the sphere of dental work. Necessary for the business, yeah, every business needs an accountant, but it isn't necessary for the practice of dentistry. Alternatively, if a dentist hires a hygienist to work 1 day a week, and instead of treating the employee as part-time, they treat the person as an independent contractor, well, that's going to be a problem because the hygienist in that example is performing work that is integral to the company and is aligned with the main type of work of dentistry, okay? That happens all the time. For some reason, a lot of employers get it in their head, and I've seen this with companies, upwards of, 500 employees, that if you're only going to hire an employee for 1 day a week, it benefits, or it's appropriate to just hire that person as an independent contractor instead of as a part-time employee. I saw one company before try and have me review an independent contractor agreement for a new chief marketing officer that was being treated as an independent contractor. You can't do it. Make the person a part-time employee. It's not going to cost you that much more. Really, the only extra benefit, if you don't provide benefits to part-time employees, is you got to pay FICA taxes and tax withholdings for the person for their part-time wage. The other thing I want to note here, and I don't want to belabor workers' compensation insurance too much, is try to make sure, check with your insurance provider to make sure that the binder establishing your workers' compensation coverage has been delivered to the New Hampshire Department of Labor. I wouldn't check with the NHDOL, but I would check with the insurance company to make sure it has been delivered and see if the insurance company has a record of that. The reason I raise this is because this past year, I had an audit that stretched out for almost 4 months that was triggered from the compliance division of the New Hampshire Department of Labor not having a record of this quite massive company with offices all throughout New Hampshire, employees in the thousands, and had no record of a workers' compensation insurance, okay? And then that led to other inquiries into payment based on commissions and the like, which is an important segue into audits themselves. Most of the time, this is how this audit started, the inspector will show up at your company and he or she will deliver sort of a written subpoena to you saying you are being inspected by the Department of Labor. Here's all the documents that I'm interested in, and please provide them within the course of generally a month. And this person was looking for thousands of documents on how people were paid. And it really all began from a simple clerical error from the insurance company and not submitting the binder to the Department of Labor. Everybody in the company had insurance, but The Department of Labor didn't know that, and that created a 4-month audit, which the company came out fine on the other side. Its house was in order, but still very disruptive. All right, number 5, failure to pay the 2-hour minimum. This one happens all the time as well. It's a little tricky, so I understand why it's generally always on this list. Employees must be paid 2 hours at the regular rate of pay when they report to work at the request of their employer, unless the employer makes a good faith attempt to contact the employee prior to the shift saying, look, you're scheduled for today. We don't need you. It's a slow day at the restaurant, for example. You send an email, you send a text, and you leave a voicemail for the employee. The employee still shows up, ready, able, and willing to work. They don't have to be paid in that circumstance because you did make a good faith effort to contact them. Otherwise, if an employee shows up for work or shows up for their shift, they have to be paid a minimum of 2 hours if you send them home early. This has become very problematic in the Zoom world. We had an audit recently at the firm for one of our clients where there was a couple of Zoom meetings that were held, maybe 30 minutes to an hour. Employees were paid for that time, but then afterwards they were sent home and they weren't paid the 2 hours that they were owed to them, even though they showed up to work, okay? And that resulted in some civil penalties and some wage adjustments that had to be owed to the employees. You know, ultimately, when you're looking at this 2-hour minimum rule, it is some ways not arcane, but not suited to a Zoom world. What it's really suited to is you have an employee who's working a scheduled shift at a manufacturing company, for instance, and they show up ready, willing, and able to do their work that day. They drop their kid off at daycare. They get in their car, they drive a half hour, they show up ready to work, and they're told to go home. Okay. The rule here is made to protect employees in that circumstance, not necessarily made to protect someone who logs into Zoom and doesn't even have pants that button. But the law is what the law is. And so companies need to be very careful with that. If you're going to have an on-hands meeting, make sure you try and have it, during a work day or during a time when pretty much everybody in your workforce is going to be there already. And for those people who aren't, well, then they're going to be owed a 2-hour minimum. Couple more comments on this. The 2-hour minimum doesn't apply if the employee shows up to work and then requests to leave because of an illness, personal reason, or because of an emergency. It doesn't apply to situations where the employee is consistently working less than 2 hours throughout the week. There might be a job where someone just has an 1.5-hour shift once a day if they're a bookkeeper, for instance. That's fine. You just have to be able to prove it. And it doesn't apply to certain healthcare employees in a community-based outreach system. Number 4, employment of undocumented workers. So New Hampshire, much like the feds, requires that every employer obtain documentation from each employee showing that they are able to work within the United States. This is interpreted sort of consistent to the limits of the federal requirements. Ask yourself right now, if you were audited by the USDOL or the New Hampshire Department of Labor, could you provide within a week all the I-9s or copies of the I-9s for all of your employees, the paperwork associated with the I-9s that has to be photocopied and maintained by the employer, and the necessary signatures of completion for all the I-9s, okay? If you cannot provide all that, or you don't know where all that information is, New Year's resolution is to start fixing it. This is an easy problem to solve. You can do a self-audit. This is something that the New Hampshire Department of Labor can just ask for as part of its inspection obligations, and it's going to be proportionate to what it's doing. So make sure you check that. Number 3, illegal employment of minors. To those who are just listening, I mean youths, not people digging holes in the ground. This one is very technical and very strict. Common violations include not having the proper paperwork, hours violations, and working in hazardous conditions, okay? If you are employing someone under the age of 16, you must provide a youth employment certificate. within 3 business days of the first day of the person working, except in the circumstance where that the employee, the youth employee, is working for his or her parents. The work is defined as casual, which is sporadic, of little productive value, and is the type of work that you really wouldn't consider to be an employment relationship. Or is working on a farm as farm labor. Those are the only circumstances in which someone under 16 doesn't have to provide the youth employment certificate, or excuse me, the employer doesn't have to provide that certificate in order to employ someone who's under 16. If you're under 16, or if you're employing someone under 16, you can't work before 7, can't work after 9, and you can't work more than 3 hours on a school day. And during the school year, 23 hours in aggregate. That changes during vacation time and during summer holiday, which is defined from June 1st to Labor Day. Between the ages of 16 and 17, the employer has to obtain written permission from the individual's employee, from the individual's parent or guardian in order to be able to employ them. There are also limits as to the time which they can work, which off the cuff here is, I think, 6 consecutive days. They can't work more than that, and they're limited to 48 hours a week, depending on the type of session, whether school's in session or whether you're on holiday or summer break. One thing that I've seen here that results in violations, I haven't really seen any working in hazardous conditions, but those types of things would be considered construction related, logging, certain types of machinery, or working with certain types of machinery that are dangerous. I haven't seen any of those cases, but what I do often see is an employer is trying to employ somebody and they're 17, but they're turning 18 in a month. Okay. And so the employer just thinks, well, they're going to be 18 in a month. I don't have to get the written permission from this individual's parent or guardian. I'll just employ them and it's going to be fine. Still technically a violation. Okay. You can either wait the month until they're 18 and then hire them without getting that permission, or you are going to have to get that permission and then keep that on record. Because if the Department of Labor comes knocking, you do have to provide it. Bottom line, the employment of minors can be tricky. If you do have minor workers, which generally this time of year isn't going to come up too often, it's mostly in the summertime, be sure to check the laws, check the regulations. And if you have questions, check with qualified employment counsel. Number 2, we're getting down there. Failure to maintain records. New Hampshire imposes strict record-keeping requirements on employers for all time worked by non-exempt employees. The non-exempt employees thing is actually a little bit of a wrinkle. Under the regulations for the state of New Hampshire, if an employee is exempt from overtime because they are a white-collar employee as defined by the FLSA, then the employer doesn't have to keep records for them. If, however, the employee is exempt from overtime, but it's because they're in an amusement capacity, the way the regulations read, there's still an argument that you do have to keep records for them. Just be wary of that. Violations for failing to keep records are significant here, and the violations really extend to civil penalties and likely wage adjustments. Because if the employer is not keeping records of hours worked, and again, that is the employer's duty, the employee can say, well, I was working 55 hours a week here, and you only paid me for 40 hours a week. So I'm owed 15 hours here and unpaid wages. And that time where I didn't work, that's overtime because we're over 40 here. So you owe me 1.5 my regular rate of pay. That can add up. And I know what a lot of you are thinking. Well, can an employee just come in and guesstimate that they worked 55 hours of work if I, as the employer, didn't keep records of hours worked or didn't keep the best records of hours worked? And the answer is yes, they can. In a litigation context, the employee is given a rebuttable presumption that their best estimate or guess of hours worked is correct. And then it's the employer's obligation to come in with records and say, no, you are incorrect. I am rebutting this presumption that you work 55 hours a week. But that's very hard to do in a litigation context if the employer doesn't have any type of records of hours worked. So please keep that in mind. So the records you got to keep here are, hours worked. I've already talked about that. You got to make sure that you document meal breaks as well. Okay. In New Hampshire, every employee is entitled to a meal break after 5 hours of work. Do not use automatic meal break deductions in your timekeeping system. It's not going to fly with the Department of Labor. The employee has to actually enter, yeah, I took a 30-minute break for lunch on Thursday. And as part of that process, be thinking, I was uninterrupted during my lunch break, and I was not in a position where I was performing work-related activities during my lunch break. So make sure that you don't have any type of automatic meal break system. Again, you got to keep records for the provision of benefits and proper deductions that are made to as well. Remember that breaks fewer than 20 minutes are generally going to be compensable. I can't think of an instance actually where they wouldn't be compensable unless they significantly add up. Okay, the only thing else I'm going to mention here is the importance of training. Okay, you know, we talked about this earlier on, but make sure that you do train your employees on timekeeping requirements, what a lunch break is, what a lunch break isn't, what the employee's rights to a lunch break are, so that the employee is able to keep track of the time they are working. It is the employer's obligation to provide you those records as requested by the employer, but it is still the employer's obligation to keep accurate records of time worked. Okay, you need to make sure you do that. I really can't stress that enough. There is nothing worse from a litigation perspective than getting into a wage and hour dispute with significant damages on the line, significant liquidated damages on the line, and not having a clear picture of the hours worked by the employee. And that brings us to number 1, which is failure to pay all wages due for hours worked. Okay, this is really a huge one here in New Hampshire. And the reason it's number 1, and the reason it's always number 1, is because it's coextensive with other violations. Okay, if you have a timekeeping violation, then you also have this violation. Because if you as the employer are not keeping accurate time records, chances are you are not paying the employee for all hours worked. Similarly, if you have a reporting issue with a 2-hour minimum, then you also have this violation as well, because you aren't paying the employee for all hours worked. All right, so this includes failure to pay overtime, it includes meal breaks, it includes not paying unused PTO when it is the policy or practice of the company to treat PTO as a wage. It includes fringe benefits, it includes travel time, donning and doffing issues, regular rate miscalculations, tip pooling violations. It is a behemoth. My recommendation for overtime here, or recommendation for unauthorized work, I guess, is to, 1, have a internet-based timekeeping system and have training. We've talked about that, but also to prevent some type of overtime issue. What you want to do is have a clear policy of the company saying that it is the company of the policy, or excuse me, is the policy of the company to ensure that you do not work overtime unless it is authorized by your supervisor. Okay, and you want to make that clear in the policy. Now, if someone does work unauthorized overtime, the solution there is not to not pay them. You still got to pay that person. But instead, you want to give some type of written warning, maybe up to and including termination if it becomes a frequent violation. What other companies do to avoid unauthorized overtime exposure, because it can add up at 1.5 hours, is to establish a 37 or 38-hour work week. And as part of its policy that you can't work over a certain amount without authorization, have that threshold be 37 hours. That way, if someone has a proclivity for exceeding that 37-hour threshold, you at least have 3 hours of regular rate of pay work that has to be paid to the employee because they're on an hourly basis and they need to be paid. But it doesn't expose you to overtime until you reach 40 hours. So you have a little bit of a buffer. I know a lot of companies that have instituted policies like that with great success. One thing that I get a lot of questions on is remote working, and how do we as the employer actually know what our employees are doing, our non-exempt employees are doing when they're working remotely? And it's difficult. The US Department of Labor, not the New Hampshire Department of Labor, issued an opinion letter on this or guidance on this. I can't really remember, at the beginning of the year. And what they said was, okay, an employer has to pay in a remote context all wages worked that it has actual knowledge of. So anything on the timesheets, if an employee, even if it's unauthorized, works 47 hours, you got to pay 47 hours if that's what's on the timesheet. Or what the employer has constructive knowledge of. What an employer should know or reasonably should know through the exercise of due diligence. If an employee doesn't put working 47 hours on their timesheet, for example, but you as the supervisor were, burning the midnight oil with the employee, trying to get a proposal out, well, then you as the company should know that the hours reflected on the timesheet aren't accurate and you need to go back to the employee and make sure that the timesheet is updated so that it's accurate and so all the time for hours worked can be paid. That said, if an employee fails to report unscheduled hours through a reporting mechanism, the employer is not required to undergo impractical efforts to investigate further and to cover unreported hours of work and to provide compensation for those hours. So there's no need for the company, on a weekly basis to be cross-referencing phone records, to be cross-referencing computer login times, just to make sure that an employee has submitted hours worked in a timely basis and that the time submitted is accurate. You don't have to go through impractical efforts, but if you have reason to know that a time record is inaccurate and that it should be more hours, you got to do something about it. So that is it for the top 10 violations. A quick note on penalties. Many of the violations that we discussed here do carry liquidated damages in New Hampshire. Some do, some don't. The ones that do, liquidated damages is an amount equal to the back wages owed. So if an employee is owed $30,000 in wage adjustment or back wages, the liquidated damages penalty is $60,000. But most frequently in New Hampshire, there are civil penalties associated with violation and not necessarily liquidated damages. On the FLSA front, however, the common courtesy is liquidated damages. But if an employer can prove to a court that it acted in good faith in the payment of wages and that it had reasonable grounds for believing that it had not violated the FLSA, it may avoid liquidated damages. You still got to pay the employee the amount owed in back wages, but you may be able to avoid liquidated damages. Under the Trump era, the USDOL was not seeking a liquidated damages penalty for any type of settlement with the USDOL. That has changed. Under the Biden administration, similar with the Obama administration, the USDOL is seeking liquidated damages for all settlements. So keep that in mind. Let's talk about the USDOL. It has been a very, very quiet year in the wage and hour division, and I'm sure many of you can understand why. The USDOL has been focused on the healthcare ETS that came out in June. OSHA is an arm of the United States Department of Labor. It has been focused on the mandatory vaccination emergency temporary standard that came out in November and has been held in abeyance since. And it has been focused on updated OSHA pandemic guidelines that employers are not necessarily required to comply with, but I've said in many presentations before, while you're not technically required to comply with those guidelines, employers do have a general duties clause. So I think it is incumbent on every employer to review those guidelines and make reasoned decisions as to which guidelines it intends to adopt and which ones it is going to forego. Now, a quick update on the ETS. Currently, it is pending before the Sixth Circuit. It will ultimately be heard by the Supreme Court. What the Sixth Circuit is considering right now is whether or not to lift the stay that has been imposed by the Fifth Circuit. Okay, then that decision will go to the Supreme Court. If the Supreme Court decides that the ETS is valid, lawful, or parts of it are valid or lawful, it could go into effect. Compliance will likely come quickly for states like Massachusetts and New Hampshire, depending on what the Biden administration does to push it out. But Massachusetts and New Hampshire do not have a plan with OSHA, do not have a work plan with OSHA. So our states don't operate with sort of a limited amount of autonomy that OSHA grants other states like California and New York and Utah and Arizona. So keep in mind, therefore, that compliance may come quickly for New Hampshire and Massachusetts, depending on what the Biden administration does and depending on what the Supreme Court decides with respect to the vaccine mandate. Right now, the USDOL has focused on skilled trades, independent contractors, and pay equity violations for its enforcement. That is likely to continue for the remainder of the Biden administration. The only real update from the USDOL that I've seen is abolishment of the 80-20 rule for tip pooling. Last December, there was a promulgated rule for tip pooling. The old rule said that an employer could use a tip credit type of payment, which is a sub minimum wage, if the non-tipped employee spends 20% of their time doing like non-tipped work. That has changed. An employer may now take a tip credit for any amount of time that an employee in a tipped occupation performs related non-tipped duties contemporaneously with or within a reasonable time, after his tipped duties. That has been, what is considered related in that context has been defined finally by the ONET at the USDOL. So for those people in the restaurant business, this should become, much easier to comply with. The new rule is far more straightforward than the old rule. That has become a final rule, I think, as of now, although I'm not sure when the final rule was published in the Federal Register. I know that it is December. I'm just not sure of the exact date right now. Tip pooling, similarly, tip pooling is lawful under the federal system now, but one caveat here is that supervisors and managers cannot participate in the tip pool unless the supervisor or manager is solely responsible for the generation of that tip. That's one instance where a manager can participate in it. Otherwise, you can mandate a tip pool for an organization, but supervisors and managers can't participate in it as normal course. Joint employment unknowns continue. In January of 2020, the Trump administration issued new rules for joint employment. It was very employer friendly. The rules or the factors for the rules are there. I'm not going to go into them because, frankly, it doesn't matter anymore. A federal judge struck down a key provision of the rule during the first part of the Walsh administration for the USDOL. He announced that he is not going to revive or fight out the joint employment issue in court. And actually, as of July, the former rule promulgated by the USDOL has been formally rescinded. So we are still in a waiting pattern to understand where joint employment is going to go in the next 3 years. Similarly, independent contractor unknowns. I mentioned before that the USDOL generally has a test for who qualifies as an independent contractor. There is not a regulatory test that I'm aware of, and there is not a statutory test. Rather, the USDOL has generally promulgated guidance as to what the test is. And that guidance is based on a collection of case law, generally circuit case law throughout the country. The Obama administration had a very onerous independent contractor test, where the principal focus on the test was whether or not the independent contractor was doing work that was integral to the business or doing work that a business needs done but isn't integral to the business at all. Again, think of that dentist practice tree example I gave you. The Trump administration rescinded that guidance and implemented a new guidance with a heavy focus on whether or not the employer controls the direction of work. The Biden administration has then rescinded that rule, and in an opinion letter from January, appeared to reinstate the Obama era rule. However, that opinion letter has been withdrawn, and the reason for withdrawal is, these letters were issued prematurely because they are based on rules that have not gone into effect. The only thing I can consider here is that the USDOL is working on a new independent contractor rule, but hasn't been developed in full yet. All right, what can we expect in 2022? Well, we're going to likely get clarity on independent contractor and joint employment tests. That is going to be very helpful. We can also expect, maybe not in 2022, but certainly before the Biden administration is up for re-election, an increase of the salary basis. In July, Walsh testified before the House Education and Labor Committee that he thinks the salary threshold, the current salary threshold of, I think, $635 is too low, and that he wants to increase it. Now, we know from 2016 and that whole debacle that $913 a week for the white collar exemption is too high. It was struck down by a court in Arizona because it placed an improper emphasis on the salary paid to the exempt employees and less of an emphasis on the duties for the employee. So I don't know where the Walsh administration at the USDOL is going to go with this. It looks like they are going to increase the salary basis. My guess is probably in the $750, $800 range, but I would expect it to be lower than $913 a week. But they may make an argument that inflation requires the amount to be raised up to, the $900 level. We may also see a revision to the duties test. There was some mention of that during the same testimony. And we are going to see an increase to the minimum wage. The federal contractor minimum wage has been increased to $15, and that is anyone who works on a federal contract has to be paid that minimum wage now. And we are likely going to see, there we go, some COVID-related litigation, and that includes tracking hours worked on a remote basis. We've talked about that. But we are also now starting to see cases based on preliminary, post-preliminary activities. So for certain industries, they had to have COVID screening before an employee was allowed to come into work. Now, for most employees, that lasts, I don't know, maybe 5 minutes. But if you have a shift starting, for instance, and you have to screen 30 employees before that shift starts, all these employees are now waiting in line. And they are doing work that they are arguing is integral to their job in the workforce, being tested for COVID or being screened to see if they have a temperature, flu symptoms, whatever it is paramount to keeping the workplace safe and COVID-free. And so they're arguing that the time that they have to wait in line and go through any type of COVID screening should be compensable activity. And the litigation on that question is just beginning to start. There has been similar litigation a couple of years ago throughout the country about Amazon employees, for instance, or employees who worked in an Amazon warehouse who had to go through a security screening at the end of their shift to make sure that nothing was stolen from the warehouse. And those lines sometimes lasted 30 to 45 minutes. The court said, however, that going through a security screening at the end of your shift wasn't something that was, integral to your principal job of fulfilling Amazon warehouse orders, and therefore was not compensable time. COVID screening may be a little different, but we'll have to see. Now, the slide that I know that everybody has been waiting for, not the question slide, though I see that there's 11 in the Q&A. I'll take a look at those. But that is the credits slide. We do have SHRM credits here for the presentation this morning. Please follow the link that is available here, and you'll be able to see that. Now I will take a look at some of the questions, and we'll wrap up here in just a few minutes. Safety plan question, is this changed? Last I knew it was one and done. Not to my understanding. I thought it had to be submitted every 2 years, but I'm certainly happy to check that for you. Another question, safety plan didn't have to be filed. Again, my understanding is that it does have to be filed, but I'm certainly happy to check that. Generally, when I'm dealing with any of these regulations, I always double check everything before I give really any type of advice because they are so nuanced. But again, I'm happy to check that. My understanding is that they do have to be provided to the Department of Labor, and they do have to be updated every 2 years. But again, certainly happy to check. If we give a bonus, we are required to give the employee a notice that they must acknowledge. Yes, I would give the employee a notice that they must acknowledge for any type of bonuses. Is written notice of benefits required each year? That's a good question. Likely with opening enrollment or with open enrollment, that likely qualifies as notice itself. That said, if you have fringe benefits that are changing, and I'm not sure what exactly you mean by benefits. If you have fringe benefits that are changing, then certainly any change, has to be given to the employee as part of the notice. If we overpaid an employee through a payroll mistake, How do we recoup those funds if we cannot deduct it from the next paycheck? A little difficult. Generally, you have to get the employee to agree to repayment, or you have to file, some type of collection proceeding against the employee to recoup those funds. It's not something that you can just take from the next paycheck under the circumstances and the regulations. Another question: if an employer is required to provide printed pay vouchers to employees each pay cycle, is the employer required to provide printed pay vouchers to employees each pay cycle, or is access to a payroll portal to view print vouchers themselves sufficient? Access is sufficient. This one's a little bit of a long question. If the employer allows employees to go in the negative for vacation and the employee is paid in advance for said vacation, can the employer take back the hours paid for vacation at the time the employee is terminated? The negative advance paid in vacation is listed on the employee's handbook. Does the employer need written permission to take back the money? I would say you got to be very careful in that situation. I would have to check RSA 275-48 to see what type of deduction may be allowed in that context. But it may also depend on whether or not the handbook treats wages, or excuse me, it treats vacation time as wages or not. And so my gut reaction here is to say that this is likely a wage and isn't something that can be deducted from the final paycheck. But I'm certainly happy to check into it. Nothing comes to mind from that statute that will allow you to do this. If the employee is scheduled for training on a non-work day that is known to be 1 hour in duration and the employee is notified ahead of time, are they required to be paid? That's a good question. What the regulations say, as I call to mind, is that the employee's work has to be, if you're going to take advantage of something being under 2 hours and known to be under 2 hours, that the employee's work has to be consistently less than 2 hours. It may be possible here that you're providing good faith notice and attempt to contact the employee to say, look, your work here is going to be less than 1 hour, and it may fall into that category of a good faith effort by the employer to contact the employee in advance. I haven't seen any regulation saying that you can do that, and I haven't seen any language in the statute allowing this, and I haven't seen any NHDOL opinion letter. I'm happy to look. My gut reaction here is that the NHDOL may understand, but you still might be audited and you still might get a modest amount in civil penalties. The way I read the statute, and again, I think the statute needs to be amended, is that 2 hours would need to be paid. Is the safety plan for employees with 15 employees or more, is this based on FTEs? That's a good question. I do not know off the top of my head whether that's full-time employees or all employees of record. I think it is all employees, but I'm happy to check. If the employer has paid lunch, is the employee required to punch in or punch out for lunch to show that he or she has taken a lunch? If you're paying an employee through their lunch break and they're getting paid no matter what, then there's no need for that requirement. The big issue with automatic deductions is when the employer is not paying for lunch, in that the employee needs to be or have the liberty to clock in and clock out for their lunch. One person, please explain travel time. What is considered travel time? That is a whole nother presentation. If we had another hour and a half, I could. The gist of it is that once an employee starts their workday, they are paid for all travel time between that workday. Okay, so if an employee reports to a warehouse, for instance, and they get specific instructions on the job they need to do in a field that day, they load up the truck, company truck, and then they take the company truck and they drive 2 hours to Coldbrook. That 2 hour commute is compensable, okay? Because the employee has already started his or her workday, okay? Now, alternatively, if that same employee leaves his or her house that morning and is going to meet a team up in Colebrook, that likely falls into a commute, even though it's 3 hours, and is not compensable because the employee hasn't started his or her workday yet. They haven't reported to a warehouse, gathered equipment, gotten instructions. They just know they got to be in Colebrook by 9 p.m. Okay. There are other regulations under the USDOL that deal with travel and whether or not the employee is, working during that travel time. Certainly, if you have an employee who's driving other employees to a job site, then that is compensable time. If you have an employee who's flying across the country and they are working on their laptop while they're flying, that is compensable time. There are, very specific regulations as to what is compensable time and what is not compensable time when you're dealing with travel. It generally depends on what the employee is doing and whether or not sort of the workday has started or the workday has ended. What is donning and doffing is another question. Donning and doffing is an expression in the wage and hour field. It's a good question that relates to preliminary and post-preliminary activities. It relates back to a case, I think in the 1980s, where employees in a Tyson's chicken factory were required to don special equipment, like outfits, in order to go and process chicken. And at the end of the day, they were required to then doff that same equipment and then, send it to laundry, et cetera. And the employees argued that the 15 minutes of donning and the 15 minutes of doffing was integral to their job and therefore was compensable time. So it's the same thing as a preliminary and post-preliminary activity. It's just sometimes it's called donning and doffing. Is the 15 employee at any time of year or just year end? Another good question. This relates to the Joint Loss and Safety Committee. I am not sure that that's actually addressed by the regulations. My sense is that it's not. Similarly with RSA 354A, and that it only applies to employers with 6 or more persons in its employee, but doesn't specify whether that's at the beginning of the year, end of the year, 3 months before a violation, whatever it is. And that's it. And final question, why would you need to have an employee acknowledge a bonus has been paid? I understand that having an employee acknowledge that they are going to get a bonus sounds like lunacy. And I absolutely get that, because look, the bonus is going to hit their account and they're going to know about it. At the same time, if you read the statute literally, which is what the New Hampshire Department of Labor does for all of these, it is going to require some type of advance notice to the employee that it is getting a bonus and for how much. Best practice is to have the employee acknowledge that. Acknowledgement isn't required under the statute, but if you're audited, it certainly pays to have that type of acknowledgement with you. And with that, we are going to wrap up today. My contact information is here. If you have questions that I wasn't able to answer today, please reach out to me. While I know a lot of the regulations off the top of my head, I do not know all of them. So some of the specific questions, I'm happy to check in them for you. With that, I want to wish everybody a very happy holiday, a very safe holiday, and we will see you in the new year. And thank you for tuning in.